Good morning. Welcome, everyone. Thank you for taking your Friday morning, midsummer, to join us. I'm Addie Rolnick. I am the director of the UNLV Boyd School of Law's Indian Nations Gaming and Governance Program. And we at UNLV are situated in Nuuvi, or Southern Paiute Territory, and we're in the middle of the desert, and we think a lot about water, consequently. And so we are pleased to be able to host this program focusing on Arizona versus Navajo Nation and what it means both in the context of tribal rights in Indian law and water. So we are joined this morning by two of my colleagues, John Tsuda and Brett Birdsong, as well as guests that we are lucky to have both from the nation and from Harvard Law School. John Tsuda will moderate, and so I'm going to turn it over to John. Feel free when you'll have a Q&A and a chat function. Please use the Q&A for questions. I can monitor that and I'll be able to ask your questions live of the panelists. I think we have plenty of time to answer them. And so again, we thank you for coming to this program. It's been a big year at the Supreme Court and a big Indian law year, even though some of those cases have, I think, fallen out of the mainstream coverage after what's happened in the last few days. We will do another program in September, focusing on the Brackeen case and kind of looking at a lot of the Supreme Court's Indian law decisions and the direction of that field. So we're really glad that you could join us. Take it away, John.
Thank you, Addie. Welcome, everybody. As Addie mentioned, I'm a distinguished fellow at the UNLV Boyd School, with Addie serving at the Indian Nations Gaming and Governance program. And so very excited to have a great group of panelists with us here. I'll be the moderator, and which means I'm going to stay out of the way and let our panelists really explain to us the decision that came down last week. We have representatives from the Navajo Nation to present their perspectives on the decision. And we also have currently two academics, our colleague Brett and also Andy Mergen, but who also spent significant time in the federal government working on these issues and can provide us some federal perspective, I think, as well. So I will briefly introduce our panelists and then let them get right into it. Leading us off will be Michelle Brown-Yazzie, who is the Assistant Attorney General at the Navajo Nation Department of Justice Water Rights Unit. And with her is her colleague Paul Spruhan, who is the Assistant Attorney General of the Litigation Unit at the Navajo Nation Department of Justice. With us is also Andrew Mergen. He was the Faculty Director of the Emmett Environmental Law and Policy Clinic at Harvard Law School, and Brett Birdsong, who is a professor of law here at the Boyd School of Law at UNLV. As Addie mentioned, there will be time for questions afterwards, but as we go along, please don't hesitate to put your questions into the queue, and we'll have those ready to tee up as soon as the panelists present their presentations. So again, happy to have Ms. Brown-Yazzie with us here. In addition to her current capacity, she served with a number of tribes, including having been a tribal court judge, has also served as a cabinet secretary for New Mexico with former Governor Bill Richardson, and as well as having served previously other presidents of the Navajo Nation. Thank you, Michelle, for being here, and look forward to hearing from you. Give us your views of the case.
Thank you, John. Thank you, all those that are joining us. Just real quickly, Tachitnin Shle, Anatlana Bashishchin, Sinajani Dashiche, Anatlana Dashanala. For my relatives, I just want to identify myself. And so what I'm going to do is just kind of briefly go through a little bit of the case background and then the opinion, and then turn it over to any questions, as well as to this distinguished panel to also give their thoughts on the case. So this case was actually brought in 2003. It was filed in the United States District Court for the District of Arizona. As folks may or may not be aware, the Navajo Nation lies within the states of Arizona, New Mexico, and Utah. And we do have many of our homes without water. We live in the Southwest and in a very arid area. And right now we're especially feeling, what the impact of the mega drought. But over time, we've always had about many of our community members, our Navajo Nation members, have had to haul water in order to and bring it from either sources within the nation or even outside. And today, we data does show that about 40% of Navajo Nation homes are still without running water, never had, plumbing within their homes. And so in 2003, after many attempts in securing our water rights through litigation and being told to, that the United States holds our rights in trust and that they are our trustee, the Navajo Nation filed its suit. And it actually was immediately dismissed. We appealed it to the Ninth Circuit, and the Ninth Circuit overturned or reversed the dismissal and allowed us to move forward with our claim. And then once it was refiled to move forward, it was again reversed by the district court. And that's when we took it back to the Ninth Circuit. And it was more recently, I believe it was in 2021 or 2022, sorry, that the Ninth Circuit once again reversed and sent the case back to the district court with the direction to allow the Navajo Nation to amend its claim once again. And so then that's when the state parties and also Interior filed for cert. Now, our claim was against Interior, and that was what our suit claimed was that the United States breached its treaty and fiduciary obligations to provide the nation with sufficient water to fulfill the promise of that the Navajo Nation would be a permanent homeland. And so we were dealing with two petitions. The first was filed by the states, and then Interior filed. And then, of course, the Supreme Court consolidated the case. And we believe, well, the two questions that were before the Supreme Court was whether the United States has a treaty-based duty to assess the Navajo Nation's water needs and develop a plan to meet them. And the second was whether a lower federal court order requiring the United States to assess the nation's water needs and develop a plan would conflict with the court's decree in Arizona v. California. And it was the state parties that were arguing that second question. And so the court did, in our opinion, is that they did focus on the treaty-based duty. And the opinion that came out basically it states that the United States does not have a treaty-based duty to assess our water rights and to create a plan to address them. We're disappointed that we did not receive that relief that we requested. However, we do not see this case as having impacted our reserved rights, our rights to water, our water rights. And the decision was a 5-4 decision, and Justice Kavanaugh, wrote for the majority, and Justice Gorsuch wrote for the dissenters. And however, the way that we also see this opinion is that 9 justices upheld the Winters Doctrine, and also in their separate opinions, did say that the Navajo Nation has a right to continue to move forward to secure its water rights through several means, either through seeking legislation through Congress, or continued litigation. And so those are matters that we are planning or that we are exploring. And also about the opinion is that we wholeheartedly, of course, agree with the dissenter's opinion, because we feel that the dissenter's opinion did track and follow the arguments made by the Navajo Nation. And so we highlight, like in having to brief our leadership, we highlight that this is a close decision, and that this will probably come up again in the future, and that we realize that with it not affecting our water rights, that we do have to continue the fight to secure our water rights. And one way that we're doing that is continuing discussions with the state, with the other tribes involved, and other water users, and trying to seek a settlement. But we do see this, although it was disappointing that we didn't get the relief, we do see this, that there were, options opened up, that there are silver linings, as what quoting from the dissenting opinion for the nation. And so that is kind of where we're at right now.
Oh, thank you. Thank you, Michelle. So next up, we have Paul Spruhan, who is the Assistant Attorney General Litigation Unit, as mentioned earlier. Paul handles the civil cases and litigating them in federal courts of the Navajo Nation, and defends the nation in a range of issues, including tribal sovereignty, environmental regulation, labor and employment, and of course, water. So thank you, Paul, for being here. I will turn the mic over to you.
All right, thank you. Can you all hear me? Yes.
Are you fine?
Okay, thank you. Good morning or afternoon, depending on where you are. As Mr. Teshuta said, my name is Paul Spruhan, Assistant Attorney General for Litigation here in Winter Rock, Arizona, in the utility room, as we call my office over here. And I want to talk a little bit to play off of what Michelle had been talking about this behind me. And this is perhaps one of the most famous renditions of the signing of the Treaty of 1868 by a Navajo artist. Also above that is a painting by an artist named Patrick Hubble from a famous photograph of Barboncito, who is discussed in some detail in Justice Gorsuch's dissent as the lead negotiator on the side of the Navajos at Bosque Redondo. Be remiss if didn't say yate to any Dene who are watching this today. This is a very important case for the Navajo Nation on a number of different levels. As Michelle had talked about, obviously we're not overly pleased with the majority's view of the Navajo Nation's claims. I think as Justice Gorsuch had indicated in his dissent, there was some characterization of what the nation was supposedly asking for in this case, that as discussed in the majority, that is not, from our point of view, necessarily accurate. But as Michelle said, silver lining, I'm going to try to remain positive about what it did do, and more importantly, what it didn't do. And what it didn't do based upon the arguments of several of the parties, not just the United States, but the state of Arizona, the state of Colorado, and a number of other amici who are attempting to do a whole lot with this case that didn't end up happening. So what did the court not do that is a positive? Number one, as I think Michelle mentioned, Winters is intact. They did not, as was sort of a concern from a catastrophic level, going to gut the Winters concept as the reserved water rights for tribes. Didn't do that. Didn't foreclose the Navajo Nation's claim to the lower mainstream Colorado River in ways prompted by the state of Arizona and its amicus brief, both substantively and procedurally. There is some discussion in the opinion. There was some discussion in the oral argument where I believe it was Justice Gorsuch who directly asked Mr. Fred Liu from the Solicitor General's office, does the Navajo Nation have a right to mainstream Colorado River water? Look over there, and didn't say yes and didn't say no. But importantly, that was not discussed, except if you read between the lines, there is at least some assumption that in fact, there is a continued claim for the Navajo Nation to lower mainstream Colorado River water. Also, there was a procedural argument that the state of Arizona danced around, heavily relied on in the lower courts, and then sort of said, oh, res judicata. Oh, but we're not arguing that. And this is this long-standing argument that since the United States did not raise a mainstream Colorado River claim in Arizona v. California, somehow the Navajo Nation is foreclosed from doing so, something, res judicata, blah, blah, blah. Court didn't say anything about that. In fact, seemingly, somewhat grudgingly, at the end of Kavanaugh's majority opinion, well, there may be the ability of the Navajo Nation to seek to assert its rights, which we're not going to say they don't have. See this laundry list, string cites of cases, including Arizona v. California. And Justice Gorsuch, even more powerfully in his dissent, says, can anyone credibly, truly object to the Navajo Nation intervening at this point, giving the long drawn-out history of the United States resistance to the Navajo Nation independently seeking to establish its rights in Arizona v. California? And the third thing, and this goes to the treaty, and I want to sort of focus in the last few minutes of my discussion on the treaty. And this is something that at least our unit deals with across a number of different legal issues, both litigation-wise and otherwise, is the treaty. Now, the treaty was the focus in this case because that was the source of the alleged enforceable right. But we litigate this in terms of what the nation's inherent sovereignty is in a civil context. We argue the treaty as it relates to what the United States procedural obligations may be when they want to seek someone who is in our custody in our own jails pursuant to the Badman Clause. We've led or have signed on to amicus briefs in a number of different recent criminal cases before the U.S. Supreme Court, U.S. v. Cooley, Castro Huerta, and a number of other contexts. So we have said a lot about the treaty in the recent past, both in the Navajo Nation courts, but more importantly in both the district court, the civil circuit, courts of appeal, and the United States Supreme Court. And so from our perspective, this is part of a spectrum of different things that arise out of this document, negotiated, of course, as discussed by Justice Gorsuch in 1868 by one of the most famous, prominent people at the time in the history of the United States, General William Tecumseh Sherman, which a lot of people don't really know. The same guy who was the Civil War general, burned down Atlanta and marched to the sea and crushed the Confederacy, had a very big interest in the West and the development, particularly railroads development, and was on the Peace Commission, whether willingly or not, under Andrew Johnson as president, who signed, interestingly enough, the Treaty of 1868, and went around negotiating these particular documents. And I think Justice Gorsuch hit the nail on the head in terms of conceptualizing the meaning of the treaty for the Navajo people in the context of what happened and where they were at the time they were negotiating. And I would strongly suggest reading it, even though it's a dissent. Okay, fine, maybe it's not binding. Why he couldn't get one vote between the people who were possible swing voters, we'll never know probably. But it discusses, I think, at least from our perspective, an accurate rendering of what was going on and therefore what the Navajos would have understood. And what is that? They were in Bosque Redondo, a very horrible, tragic place that for several years were kept as prisoners in this sort of Christianized laboratory in an attempt by, I guess at the time, seemingly well-meaning from their perspective, military agents, crushed resistance, starved the Navajos out in the middle of winter, and forcibly marched them. And as Justice Gorsuch talks about, it's actually 53 different events, all the way from just north here in Fort Defiance, the place is still called Fort Defiance, all the way to southeastern New Mexico, which if you know anything about the topography and the environment, southeastern New Mexico is extremely different than the environment of the Navajo Nation on a number of different levels, including its ability to do irrigation agriculture, because the water, as was discovered at that time, was not conducive to actually growing crops in Bosque Redondo. Now, one thing that a lot of people don't necessarily know, Navajos were not just hunter-gatherers. There was a strong agricultural society, corn, nadan, if you will, in Navajo, extremely important, not just for the diet, but for the entire cultural structure of the Navajo people. And Barboncito, as Justice Gorsuch correctly notes, talked about this in a lot of detail as to exactly what they expected when they returned to the Navajo Nation. They would have water because they had already been growing crops and had been used to the idea of having access to be able, not just for livestock, but also for livestock, but for the pre-existing agricultural aspects, both spiritual and subsistence, to grow corn and other crops. One of the interesting things that our good friend Mr. Kit Carson figured out quickly, particularly when going into Canyon de Chelly, the way to crush the Navajos is to cut down and destroy their peach trees. Another way to do it is to fill, destroy, or poison wells and water access. And so the idea of water not being a central part of the consideration of the negotiators of the treaty on the Navajo side, and as understood by General Sherman, is a little questionable, shall we say. So what does this mean? What does this mean for us in terms of the treaty? Now, if you read the majority opinion, there seems to be some suggestion that if it ain't in there in plain English, as interpreted by judges in 2023, it's not real. I would tend to say a little more nuanced analysis on that point. I don't know that that is an accurate way of dealing with this case. Obviously, we're biased, so obviously we're going to interpret it in a particular way. And I want to emphasize both Michelle and I are speaking here in our official capacities as the Navajo Department of Justice. What I might personally believe this opinion does or does not say, I'm speaking from the perspective of the official views of the Navajo DOJ and the Navajo Nation. It's quite limited. Does it mean the treaty doesn't say what the Navajo say it say? No, it does not. Why? Because from our perspective in reading the case, it is applying a specific lens, a very high level of scrutiny by adopting this Hickorea standard, which we do believe is incorrectly applied in a non-money damages context for all the reasons that Justice Gorsuch talks about, that Justice Kavanaugh sort of waves away in a footnote. No, something separation of powers, Tucker Act, what's that? No, it's the same standard, Hickorea, because the Solicitor General said so. There's sort of an interesting context here where Kavanaugh is essentially saying, as the Solicitor General has said, here's the law, as opposed to, as the Solicitor General argued on behalf of the United States in the context of this case, this is what they think it is, but it isn't necessarily what it is. Justice Kavanaugh basically says, well, they said it, there you go, that's the law. But once you apply Hickorea, whether we like it or not, and once you agree that that is the standard, then it seems to me that the outcome of the majority was going to be the way it is. It doesn't say water in the treaty. Okay, well, it says a chapel. Well, if they said that they agreed to a chapel and they didn't agree to water, that must mean it's not in there. Okay? So from that perspective, it is extremely limited in that our view, and we have so stated in public statements since the case has been issued, the President, the Attorney General, and others. What does this case mean for us and other tribes? Under this heightened standard that requires express or specific, the language of the Treaty of 1868 does not have a specific obligation to do an assessment and create a plan. Period. End of story. That's all it means. And that's it. Does that mean, again, that for other federal officials, Department of Interior, Congress, United States Department of Justice, even perhaps, when it's not in a defensive litigation mode, that the treaty doesn't say that the United States doesn't have a trust obligation, that they can do whatever they want with the trust corpus and there's absolutely nothing that the nation can say about it? No, we don't believe that that's what it says. The nation, of course, can advocate its views as to what the treaty means to the political side of the federal government. Kavanaugh essentially says so. In his, we have to stay in our constitutional lane, so not our problem. Go talk to somebody else. Okay, we'll go talk to somebody else. So from our perspective, this doesn't mean that the treaty doesn't say what we think it says. It doesn't mean that even other branches of the United States government necessarily have to or will or do believe that that's what the treaty says and is so limited. And so from that perspective, as I think Michelle has talked about, we're currently in litigation, the Little Colorado River, we're in negotiations. It's business as usual for the Navajo Nation. We will continue to advocate in all forums as appropriate with anybody who will listen to us to get what ultimately should be a small ask. Clean drinking water for the Navajo people on the Navajo reservation. Period. End of story. All right, I'm a little early, so I'll stop. Thank you.
Thank you, Paul. Appreciate your explanation, particularly to folks who maybe haven't read the case and seen or read through Justice Gorsuch's great historical rendition. Thanks for sharing that with our people attending. Next up, we have Andrew Mergen, and as I mentioned before, Andrew's now an academic, but prior to joining the Harvard Law School faculty, he served in the appellate division of the Environmental and Natural Resources Division at the United States Department of Justice for over 30 years, and in that capacity presented numerous, by his count, over 80 oral arguments in federal courts litigating water rights issues, et cetera, also in state court. So very happy to have you here, Andrew, and appreciate, while you're no longer there, a perspective that I have always found unique from the Department of Justice on Indian issues. Take it away.
Thanks very much. Really terrific remarks by Michelle and Paul, and I agree, as I'm going to come back to that. I think that this decision leaves a lot open for the Navajo and for Indian country. It could have been a lot worse, and I want to talk about that towards the ends of my remarks. We're at the point of the Supreme Court term where today was the last day of opinions. It's officially over. Personally, it's a huge relief, right? We don't have to worry about any bad news showing up from the Supreme Court until we're back into later, and maybe after the long conference or October. At this time of year, like what the pundits do and the lawyers do is they look at the court term and they look at the decisions, and one of the things that's very common for pundits to do is to break it out to how did the government do, how did the Justice Department do, how did President Biden do on his agenda, how did Solicitor General Perry-Lager and her team at the Justice Department, how did they do, right? And the government and the Biden administration lost some huge cases, right? The Clean Water Act case is a case that will impact the nation. It will impact Indian country, all in a very adverse way. It is a truly terrible decision. I can say that because I don't work for the Justice Department anymore. I can be sort of candid. The affirmative action cases were lost yesterday. The student loan cases were lost today. But there have been some bright spots for the government, and the brightest spot, I think, for many of us is the win in Brackeen, an enormous win for Indian country, for the Justice Department, for all of the folks who put so much work into that. Same team worked on Brackeen, Fred Liu, who Paul mentioned, and Ed Needler, who worked on the Colorado case. And the Colorado case, the Navajo Nation case, will go into the column as the pundits look at the Justice Department's record before the court as a win, right? The court largely adopted the arguments that the Justice Department made, and I think in a good way followed some of the roadmap that the government laid out, a roadmap that I think prevented a worse outcome. It's a very disappointing outcome, I realize, but I think it could have been worse. And I think part of the reason that it was not worse related to the government's briefing and the excellent briefing by the tribe of the amicus that kept the worse outcome from occurring. I want to say that from my perspective, as someone who spent a lot of time in the government, the position that was staked out in the government's brief was very much a long-standing government position. That is to say that the government has long required in a breach of trust case that the duty that has been breached be very clearly laid out. The government's view, as it is stated in a number of briefs, right, is that there is a trust duty between the United States and tribes and Indian people, but the contours, because the United States is a sovereign, the contours of that relationship are really defined by particular enactments, the enactments of Congress, the actions of the executive branch. And this goes to a point that I think Paul made really well about how much is still available here, that there is a trust duty that in some ways is contextualized and given content by what the executive branch will do next, what Interior will do next, what Congress will do next. But the government's position has always been that there's nothing sort of amorphous, right? It has to be very clearly stated when you're bringing a breach of trust action, what duty has been breached. And that, the notion that the Hickory applies only in the Tucker Act cases, I understand the argument, but I think it is largely inconsistent with DOJ practice over the years. In my days, way back when, I defended breach of trust cases in Phoenix Indian High School, and the exchange with the Collier company there, and we made the same argument, right? No sort of freestanding trust duty. It has to be very clearly expressed, and this is consistent, right, with the role of the Justice Department and the government in sort of managing the affairs of the executive branch, right? So it goes above and beyond Indian law. One of the cases that Kavanaugh mentions in the majority opinion that the government made a point of in its briefing is the famous SUA case, right? SUA v. Norton, which is a Bureau of Land Management case about whether the Bureau of Land Management essentially had a duty to stop off-road vehicle use on some lands in Utah. And Justice Scalia wrote an opinion and said, it's just not clear enough, right? If you're going to essentially seek a mandamus form of relief, it has to be express. And that's sort of what the position the government took here, right? And it's consistent with sort of a long-standing practice of the government in these cases. And I totally agree with Paul that in terms of what makes this case tricky is the treaty aspect, right? And I totally agree with Paul that I would not overread what this case means in terms of how treaties should be interpreted by the executive branch, by DOI, by Congress. But I do think that in the breach of trust context, right, this sort of black letter duty has long been part of the government's sort of defense in these cases. Now, I think there are a couple of reasons there that this case, Kavanaugh didn't write very much. And I think that's a blessing, right? And I think that there's some very important wins baked into this opinion. I think it was good that looking at this as somebody who is operates a ton in the environmental and natural resources space is that Kavanaugh does not deny the importance of these issues, right? He refers to the historic drought conditions in the American West. That maybe seemed like a very small thing for many of you, but given the hostility that the court has expressed to environmental regulation, to climate initiatives, the notion that somebody is sort of saying, yeah, the normal here is this is an arid place with a really bad drought situation. I think that it's not much, but I found it heartening. I coupled it with the fact that Kavanaugh joined with the dissenters in the Clean Water Act case. I think Michelle and Paul have made a really important point here with regard to the winners paged use. That we emerge from this case with a winner's doctrine, really, I think Michelle put it, acknowledged by 9 justices. I think that's a really nice way to look at it, right? There's nothing, Winters is this fantastic and important doctrine, but query whether anybody thinks that this court, so obsessed with textualism and so skeptical about sort of implication and purpose, would find anything akin to the Winters doctrine today. And I think it's so important that Winters emerges from this as sort of settled law, because we know that there are lots of interests, water interests, that want to diminish the Winters doctrine and to make it smaller. And we avoided that result. I think that another important thing here is this issue of intervention under Rule 24. One of the things that hasn't been mentioned, but I think is important to sort of the injustice here, is that in the Arizona v. California case, the intervention of the Navajo tribe was opposed by the United States, and they were denied a seat at the table. That is a point that Justice Gorsuch makes in his opinion, and in concluding his decision, Justice Kavanaugh says, as things move forward, the Navajo should intervene, and this actually takes an argument sort of off the table for the Justice Department, right? Sometimes the Justice Department and the government argues, hey, we got you. We're your trustee, right? You don't need to be in this case. We've got it. Having you in this case would be duplicative here. That's going to be a very, very hard case to make based on the eloquence of the Gorsuch dissent that Paul has identified and the statements in Kavanaugh's opinion itself. And then finally, one last thing that I would mention is to the silver lining, I think, of this case. And maybe the panelists and others would disagree with me, but the government's brief was really, really carefully written to avoid having the court get to this second issue as to whether or not the Arizona v. California decree foreclosed the Navajo from pressing these claims, right? And the government sort of briefs this sort of breezily in its brief, the whole time saying, stay away, don't touch this. Please, 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 just resolve this on the notion that there's nothing compelling us to the government to do something affirmative. And I think that is a huge win that we all ought to be thankful for, because I don't think we want these justices wading into the law of the river and Indian water rights in the context of this case, where the issues have only been briefed in sort of a drive-by fashion, and where, given the circumstance in the Southwest, given the circumstance along the Colorado River, I don't think we want the court sort of unnecessarily weighing into the law of the river. These are complicated issues, and we know, I've been involved in water rights litigation for 30 years, a lot of it in state court, which is a difficulty for tribes, and it's a difficulty for the federal government. The McCarran Amendment allows that to happen. And, a stray comment here or there can take on an enormous relevance in a state court proceeding or somewhere else. And we have avoided the Supreme Court wading into that issue by not touching the issues that Colorado, right? Colorado AG Phil Weiser, former dean of the Law School of Colorado and Arizona are sort of putting those issues out into play, and the court avoids them. And I think that's a big win. And I will stop talking. Thanks.
Well, I hope you'll keep talking. I'm sure we'll have some good questions, Andy. Thank you very much. Next up, we have Addie and my colleague, Brett Birdsong. Prior to coming to the law school and entering academia, Brett worked for more than 2 decades in the federal government, pushing forward high-stakes conservation initiatives for the Department of Interior, and working on those on behalf of numerous land and water conservation issues. So, Brett, you've got a great perspective, and I think one of the things that we don't want to lose sight of is the importance of this decision. Also, as Andy alluded to the states and other folks. The river is depended on by a great number of folks, and however this decision came down, it was liable to have some impacts on those other players, even those who are not entered, like the states of Arizona and Colorado, who are not entered into the case formally. So I look forward to hearing from you. Thanks, Brett.
Great. Well, thank you. And I largely agree with many of the points that have been made by Michelle and Paul and Andy. Most particularly that this could have been a lot worse. And there are ways, of course, I guess we all want to read opinions that come out against our interests or that we just disagree with in the most narrow way possible. But there really are some important silver linings in this case. What I want to spend just a few minutes talking about is first just some general thoughts about the opinion, and then maybe with the help of a few charts or maps to sort of put it in the context of what's going on in the Colorado River, and particularly the lower Colorado River basin, which those of you who don't live here in the lower Colorado or in the Colorado River basin, you've probably been reading about it, but we have been really increasingly feeling the impacts of deepening crisis on the Colorado River. So I want to sort of just try to put this a little bit in the context of that and what it means also for potentially resolving ultimately the nation's claims to water, particularly on the lower Colorado on the main stem, which of course are unresolved and which all 9 justices recognize as existing but undefined or unquantified at this time. So I guess my overall thought about the opinion when I finished reading it, I thought, well, wow, this opinion and the dissent will almost certainly end up in jurisprudence case books in the future as sort of just exhibiting 2 starkly different approaches to how to determine legal questions. Justice Kavanaugh wants it to seem like a small issue. He comes at it from a sort of traditional formalist approach, looking at institutional interests, at the lanes of the branches of government, and kind of making it seem almost like a cold, clinical type of decision. Well, we've just got these lanes and we've got separation of powers, and we, the courts, aren't going to really get involved here at all because it's not our lane, and focusing on that. He does sort of recount the history, but in a very high level schematic way that is really just necessary, just the amount necessary to sort of explain his institutional approach and the institutional interests. On the other hand, Justice Gorsuch, whom I would not normally expect to take this approach, really has an extremely nuanced historical approach. Doesn't address the law until a very fulsome discussion of the history of the treaty negotiations. Obviously, that's a reflection, I think, of the excellent advocacy that was done by the nation to set that out. And then really only turning to the law in the context of that deep and important history. And so, I really think that just the style of jurisprudence of judging among those 2, this is a really stark contrast in those decisions, or among those 2 opinions. So let me turn a little bit to the context of the lower Colorado, and this is particularly for the benefit of those of our participants who are not necessarily living the Colorado River crisis on a daily basis, living in the basin. So I think one of the reasons this decision has been closely watched outside of Indian country as well as in Indian country is because of this deepening crisis we have on the Colorado River in general. And I'm going to show a couple of pictures, or actually just maps and charts that I think help sort of frame that up. So bear with me while I share my screen. I think everyone should be able to see this. If there's one picture about the Colorado River basin that I think frames the importance of not just the Navajo Nation's claims, but the situation on the Colorado River, it is this one. So this is a historic depiction and a prediction of water use, which is the red line, and water supply, which is the blue line. So what you'll notice, and this is basin-wide, so it comes from a study done by the Bureau of Reclamation a few years back. What you should notice is that for most of the past history up until about the year 2000, the blue line, the supply, ran above, in some cases well above, the red line, which is the water use. And if you look into the future, you see that the red line is consistently, significantly above the blue line, that the water demand or use in the basin is predicted indefinitely to exceed the projected supply. And so one of the issues with this is that it depicts essentially a structural deficit. So one of the things I picked up in the Kavanaugh opinion and the majority opinion is that he did take some pains to describe the water rights situation in the West more generally as a quote unquote zero-sum game. And for the most part, that has not been true of most of the West. I mean, it's a zero-sum game in the sense that somebody might have a priority right to use water that would prevent somebody else from using that same water in a way that interferes with it. But for the most part, reserve rights settlements have not been a zero-sum game. They have been, and they have certainly not been a zero-sum game in the sense that recognizing tribal water rights displaces established uses of water. Rather, they are the result of settlement negotiations that typically and generally will recognize or protect existing non-Indian uses while also providing for the development of water resources to meet tribal needs. When you have a structural mismatch or a structural deficit, such as depicted in this picture, the risk of zero-sum increases, and I think that's one of the realities on the lower Colorado, and it will be a challenge perhaps for the tribe, although there's lots of ways to sort of because of the physical attributes of water to diminish the zero-sumness. But I guess I was a little bit disheartened to see Justice Kavanaugh describe water rights necessarily as a zero-sum. So one of the aspects of this case that I think makes it somewhat unique, and it's sort of in the I guess in the category of what are the ways to narrow the bad parts of this decision and to focus mostly on the good parts. One of the unique aspects of it is the role of the United States with respect to administering water rights on the mainstream of the Colorado, particularly in the lower basin. So the Compact of 1922 divided the river into the upper basin, shown here in the greenish color, and the lower basin shown in the tan color. And it basically said, look, the upper basin can use 7.5 million acre feet consumptively. The lower basin can use 7.5 million acre feet consumptively. And the dividing line is Lee Ferry on the river, actually just across the river from Navajo. And so that's all the compact did. And then the individual allocations among the states are determined in the upper basin by a separate compact in 1948, and then by in the lower basin based on the Supreme Court's opinion in Arizona versus California in 1963, where the court said that Congress and the Secretary of the Interior, acting through congressional authority under the Boulder Canyon Project Act, which resulted in the construction of Hoover Dam, allocated water among the states in the lower basin. And so that puts the Secretary of the Interior in the United States in a sort of unique role with respect to Colorado River water on the lower basin. The Secretary not only determined the amount of, through authority under the statute, the allocation among the states, but also operates all of the infrastructure in the lower basin that actually allows that water to be delivered. And so I would say that it's a unique situation that the United States here plays the role of water master in this interstate water system in the lower Colorado, that in some ways might at least allow us to think about this case as not quite sui generis, but unique or near unique in some ways. Just for a couple of things about, I'll just point about this case, or this picture actually. This picture is somewhat typical of many pictures of the Colorado River Basin. It pretends that the river exists only within the United States. It ignores tribal nations and lands, depicting just the United States and a more sort of accurate picture of it would be this, which shows the federally recognized tribal lands within the basin. And it also recognizes, of course, that the river continues to flow into Mexico and that it's an international river as well. Just by way of situating, this is just a zoom in that shows the area around Lee Ferry and the Glen Canyon Dam, as well as Navajo here, which sits on the southern bank of the river and which straddles both the upper basin and the lower basin. So there's been some talk from Paul and Michelle about the nation's claims to lower main stem water. And except for those, for the most part, lower basin water is delivered from Lake Mead and from Hoover Dam. And so much of the crisis talks that have been going on around the lower Colorado River have to do with ensuring that the water levels in both Glen Canyon Dam and Hoover Dam do not fall to levels that would impair the ability of those dams to actually deliver water. In other words, fall to either dead pool or fall below certain levels, which would allow for water to be delivered for various purposes downstream. And the talks that have been going on, there was a big settlement among the states, or agreement among the states in June or in May, just recently within the last few weeks. And there are talks going on to determine what is the future of those of water use in the lower basin if we continue to face the structural deficit that my first chart depicted. And and I think that's an important aspect. I guess what I have always viewed this case, and maybe it's saying too much, and I'd be interested in hearing Michelle's and Paul's view of that, as a way for the nation to ensure that when the secretary reviews and either approves or disapproves, or even participates in the negotiations around the future of the Colorado River, will have a firm understanding of what the tribe's water rights are, what their needs are, in order to make sure that even though those claims right now are unadjudicated, those rights are unadjudicated, they are recognized and protected, and that as these decisions get implemented down the road, it will be done in a way that will protect those tribes' water rights. And so I guess I'll stop sharing here, and I think my concern about this case, even though there are plenty of silver linings and less bad outcomes, is that if there were some sort of duty for the secretary under the trust responsibility that was enforceable by the courts in some way to make sure that those rights were being protected as the future of the Colorado River for the next few decades is determined through these negotiations, that would be a lot better for the tribe than what is left, which is, sure, 9 justices recognizing winners' rights exist, that the tribe has rights, that in a sense, the government is holding on to tribal property and has some responsibility toward that, but only in a sort of non-judicially enforceable way, except through these mandamus-like principles. I guess let me just sort of close with a quick overview or just thoughts on what does this case mean for winters' rights or for Indian reserve water rights more generally. First of all, I wholeheartedly agree. It could have been much worse. This court recently has shown little concern about overturning legal precedents that have been around for decades. Winters was perhaps at risk, and I'm glad to see that, as Michelle suggested, 9 justices have accepted Winters as the law of the land. That is really important. I do, in reading the tea leaves, see some troubling signs. And I guess I would suggest that advocates for Indian reserved rights be aware of these and think about strategies to address them in the future. One of the things that struck me first off is that the very first cite to a case involving reserve rights in Justice Kavanaugh's opinion was not to Winters. It was to a case called United States versus Capert, which is not an Indian water rights case. It's a federal reserve water rights case involving non-Indian federal land. Now, federal reserve water rights are, of course, similar in theory to Winters' rights, but they are not the same. It's sort of like to treat them the same is to take the Indianness out of Indian water rights in some way. And I found it striking, actually, that when he said this case involves reserve water rights, the very first case he cited to was Capert and not Winters. He had a C also cite to Winters, of course, in that first one. But I guess to me, that signaled that there might be a tendency or even an effort to erase any distinction between Indian reserve water rights, which are often based on treaties, on longstanding and deep historical circumstances, versus federal reserve water rights, which really are narrowly defined by acts of Congress or the executive under their enumerated or other powers. So find that somewhat troubling. And I guess the reason I find that somewhat troubling is that if you look at the reserved water rights cases in the Supreme Court after Winters, particularly those involving federal reserved water rights on non-Indian lands, there has been a parade of narrowing language. The water is the minimum amount necessary to fulfill the purposes of the reservation. The water is only the amount that would prevent the purposes of Congress from being totally frustrated. Those sorts of limiting notions. And so I'm concerned about the apparent wanting to erase the distinction between, say, Indian Federal Reserve rights and Federal Reserve water rights, because it would maybe suggest that that narrowing language in those Federal Reserve water rights cases might be something coming down the pike in Indian water rights cases as well. Now, these issues, of course, have been litigated in state courts under the McCarran Amendment for decades, but never has the Supreme Court sort of really addressed it with this. And so, again, this is really a tea leaf kind of analysis, but it's for me, it was the cause of not quite alarm, but significant concern. So I'll stop there and let's get to some questions, I guess.
Great. Thank you, Brett. Appreciated those views, especially stemming beyond just the boundaries of this case and water, the larger questions about water in the West. So that concludes the formal presentations for our panelists, and I would encourage our attendees to ask questions. There is a queue for asking questions. If you can put those in there, and we can make sure to try to get to everybody's questions before our webinar ends today. So I don't believe we have any in the queue at this point. So while we're waiting, I will go ahead and throw a question or two out to you guys, and maybe we can start some of the discussion that way as well. And I'm curious. So I have had some experience myself with dealing with the quote federal family. I know Andy and Brett, you both had experience with that as well from the inside. And what I'd like for you guys to maybe give us some insight into is that within that family, and if you look at it from the Solicitor General's briefings, et cetera, it purports to present sort of a common view that the United States holds, and that's obviously what they intend to do. But we know that within the government, and particularly on these kind of issues between the Department of Justice and the Department of Interior, there are some strikingly different views sometimes on these types of cases. And so maybe you can give us a little background on that would be helpful, and also help address a question that I have, and I'm sure some of our attendees have. It's discussed in the cases, but it seems illogical in a way to have this position by the federal government, which is to say simply, yes, we have a trust responsibility. We have a trust responsibility for a particular asset, this water, and we know that we hold it in trust for the tribe. We just don't know how much it is, and we don't want to tell the tribe how much it is. That seems a little illogical. So can you help us understand how the United States itself can kind of hold this conflicted view and position of its responsibilities?
I can start it. I want to say that I'm here to explain the government, maybe not to endorse it, right? So I'm hoping that my perspective will be valuable as somebody who, as the Cuban patriot Jose Marti said, I know the monster I've lived in its entrails. So I can give you a perspective, I think, on where the government's coming from. And I want to pick up on something that Brett said in responding to this question, which is like the purpose of this lawsuit and the ability to get a definition of the Navajo Nation's rights to to be able to make sure that those rights, the rights of the nations, are safeguarded as we have all of this activity going on in the Colorado Basin and the Lower Colorado Basin. Nothing prohibits DOI from just going ahead and doing that. And that's one of the things that I think is a silver lining about this case, as opposed to some of the other losses, big cases this term, like the Clean Water Act case. Only Congress can fix that. The DOI can go out and undertake any sort of study it wants at this point to fully understand the nation's claims and rights here. And I think, to go back to your point, John, yeah, there is always tension, right? And it's not just tension between DOJ and the Department of Interior, and it's always the small c conservatism of Justice Department litigators interested in protecting the overall institutional interests of the United States. And so I think what the Justice Department would say, and I'm not speaking for them, is there's a big difference between our ability to sort of internalize a trust duty that says we need to go out and do this, right? We need to undertake this study. We need to go out and make sure that safe, clean drinking water is provided to the nation. And there's a difference between undertaking that duty and being compelled to do it by the court. And the rationale behind the government is, we want to control the government wants to control its priorities. The government wants to set its priorities. The government is best situated to know the challenges, the resources that it has to deploy those resources. And hence, in litigation, not just in these cases about trust duties, but across the board, is to sort of keep the courts out of the executive branch's business, so to speak. And this is incredibly frustrating, I understand, because there is a duty. I think everyone in the federal government recognizes this duty, but the Justice Department's position has long been that as a legal matter, Congress, consistent with Congress's plenary authority over tribes and Indian nations, an authority, right, that Justice Thomas sometimes expresses some doubt as to, but that gives content to this trust responsibility. And, sitting at the Department of Interior, the secretary could say, we're going to make this study. We're going to make understanding Navajo Nation's water rights our #1 priority as an expression of our duty to the nation. That's fine too. That is a legitimate way to frame that responsibility, but it's not judicially enforceable. And I think the way to think of it is that, everyone jokes, I was told this yesterday, that when you litigate the government, they never want you in, right? No waiver of sovereign immunity. You don't have standing. Case is moot. Case isn't right. And that's because institutionally the government is trying to maintain its authority. Same with the tribes as regard to Rule 19 and sovereign immunity. No, it could be a lawsuit, any sort of lawsuit. We want to maintain our set of priorities. We don't want to hand over this to the courts. And so, I think that's sort of what drives the government's position in these cases. But I just want to say one last thing. There's a lot of tension, right? And there are, as you sort of very well put it very well, John, there's a range of opinions in the federal family, and it is extraordinarily common for that range of opinions to be expressed through the crucible of writing a Supreme Court brief or writing a cert petition. And for sure, right, we can imagine, I'm not saying that there were or there weren't, but we can imagine that there were probably a lot of expressions of views to get to where that brief landed, right? And a lot of views were heard, considered, not considered. And I think, in some respects, the brief, which is frustrating, was helpful in terms of, I think, doubling down on Winters, and in terms of avoiding the court's interference with greater law of the river issues. I know that's called comfort, but I do think that that's the kind of thing that emerges from these tensions in the federal family.
Brett, you got anything to add?
Well, I guess I am dismayed, I guess, by the court's cartoonish view, I'll say, the sort of extreme reductionism that it's either this or it's that. It's either the full-blown common trust principles or it's extreme unfettered discretion. And and here it said, well, we're going to treat this. It's not full-fledged common law trust principles that apply here. It's and sort of the analog to that is a sort of federal mandamus. It wants to think about the federal responsibility here as being either explicitly defined with no discretion by either statute or executive or treaty law, right? Or else it kind of is unenforceable. And I wish that the court would understand that there really is something that's probably workable, that's in between unfettered discretion and defined to the letter of the law with ministerial precision. And that, I think, is to recognize, hey, there's a trust duty here and the government isn't doing enough. Now, it might not be the role of the court to say exactly what the secretary or the government should be doing to fulfill the trust responsibility, but I can say that what they've been doing is not enough and they have to do more. And I'm going to maintain jurisdiction at the same time as recognizing discretion for them to say, here's how, okay, we lost, we realize it's not enough, we're going to do more, this is how we're going to do it, and to sort of have continuing judicial supervision over that kind of action by the executive.
Great. Thank you, guys. We have a question in the queue from an attendee. Let me ask that, and I'll throw it open to any one of our panelists if you want to offer a viewpoint on it. So from one of our panelists, he asks, if the Department of Interior can secure native water rights, why has it not done so 20 years into the biggest drought in the last 100 years? Maybe the analog to that is to build off of somewhat off of the Kavanaugh majority opinion, which is to say, we need to stay in our lane, the court, we need to stay in our lane. This is a responsibility of the executive. And I think, at least I think part of what our attendee is asking is, this is a big responsibility of the executive. Why aren't they doing anything about it?
Yes, I would throw out, it's an excellent question on the part of the attendee. I guess I'm not as familiar with this issue as probably maybe Brad and Michelle and Paul, but the IRA sets aside an enormous amount of money to settling Indian water rights. And I wonder if is there any reason for optimism in terms of the executive branch moving on this in the future?
Are you referring to the recent appropriations for the Indian water rights settlements? So, I think that was actually a response, a reaction to how the impact of COVID on Indian communities, and the fact that there have been settlements in place, but not funded in order for the tribal communities to actually realize those settlements. So the funds are to help develop infrastructure for water to go out to the communities. And we definitely welcome that. And the Navajo Nation did receive some of that funding towards its settled water rights, or its settlements, and the infrastructure that we're trying to build out in Navajo. So, and we currently, my unit is working on additional settlements in the state of New Mexico, and we have the Navajo Utah settlement, and we're working towards implementation of that. And we do have, the Navajo Gallup Water Supply Project. That's the project that receives some of those funds. And however, it was underfunded, and we're having to seek, additional funds to complete that project. And in Arizona, we are working on infrastructure. However, we don't have a settlement. And the best part of settlements is the funding to build out that infrastructure. And so because of the need in Arizona, the tribe itself is financing, a pipeline to serve its communities. But if we had a settlement, it would greatly help, our effort.
I guess I might just add 2 points. One is that I think, John, when I worked in the solicitor's office for Hillary Tompkins as a deputy, I didn't deal with Indian issues or Indian water rights issues at all. But we kind of had this saying that this isn't really a department, it's a holding company, that there are so many different agencies with different missions within the Interior Department, all of whose authority is really secretarial authority, ultimately, that it's just an extremely complex organization that's like a microcosm of the United States government itself. And so I don't know, because I haven't been deeply involved in these Indian water rights settlements or negotiations, but I think one of the historic difficulties has just been that those other interests by the other agencies, whether it's a Bureau of Reclamation or other agencies, have simply taken all the oxygen in the room and basically crowded out concern about Indian water rights. And so, I think that that's a continuing problem. And so I guess that's one of the reasons. I mean, I'll relate that to my comments earlier about sort of, isn't there some in between with respect to the trust responsibility, which is the ability for the courts to say, you're not doing enough. I'm not going to tell you exactly what to do, but you're not doing enough, and come up with a plan or come back and report to the court about how you're going to actually meet the responsibility. I guess that was really only one major point, and I'll leave it at that. And it's not an excuse. I think it's just an potential explanation.
I'm guessing that Paul and Michelle, as many tribes do, would say, because of the trust responsibility, there is a paramount priority amongst all those other priorities, and that's the tribal priority. Does anybody else have a comment on that question? Great. So I'll ask another question by one of our attendees here we have in the queue. The question is, some tribes are interested in protecting in-stream flows for cultural and environmental purposes. Do you think that the Navajo decision will have an impact on efforts to encourage the federal government to protect those type of in-stream flows?
I'll just say I don't think it does. It recognizes Winter's rights if there is a claim that can be put forth within the Winter's context that in-stream flows were part of what was necessary to accomplish the purpose for which the reservation was either established or recognized because of Aboriginal history, then I think that there's nothing in this opinion that would suggest that should be limited in any way.
Yeah, I agree with that. I found Brett's comment about Capert and Kavanaugh leading with that non-Indian reserved rights case an interesting one. I sometimes think they want to lean into something that's more recent when they include the citations. And I hadn't really thought about the risk of bleed over, but I will say that I think Capert was foundational to the win by the Agua Caliente on their groundwater rights, that they couldn't, that Capert really provided a foundation for that important Indian reserved rights decision. And I would say that I still wake up happy that the court denied cert on Agua Caliente, because that would have been a bad reserved rights case to get to the before the court. But I tend to agree. I don't think that this decision will affect in-stream rights one way or the other.
Thanks. Thanks, Andy. So let me ask this question. Was on my mind. I'm sure it's on some of the attendees' minds. So our attendee asks, if the United States does not have an obligation to identify and account for Navajo Nation water rights in the Colorado River, who does have that responsibility?
That's a very good question. So, you know, it's very clear that the United States still holds our water rights in trust. So what the nation was asking for was an accounting of that trust corpus. And that was basically, you know, what this case was about for the nation was, so we know we have a need for water and access to it. And so we wanted to have an assessment done and to have a plan put in place for it. And what's interesting is even during, you know, the oral arguments, some of the questions that were being asked of the US attorneys was, well, how much water is there? And they couldn't answer that because, you know, the whole point of the case was to assess what was available and what our needs are. And they couldn't answer that question. So very good question. And I wish I had the answer to that.
Good. And, you know, I've been sitting back and not commenting up until now. Interesting related to some of the other comments by Andrew and Brett. You know, if you're not a lawyer and you're not a defense attorney for a sovereign, this all sounds really strange because we own the water, you don't. At least we're the trustee, whatever that means. But we can't and won't tell you how much there is, and you can't make us. And we'll sue when we want to, and we won't when we won't. And if you try to come in, sometimes we'll let you grudgingly in that we won't object to permissive intervention. But if you try to do, and I think Andrew mentioned Rule 19, one of our favorite rules of civil procedure here as defense attorneys for the tribe tries to get in claiming the United States doesn't adequately represent them, which of course is a requirement under mandatory intervention under Rule 24. The United States will almost always, if it says anything, oppose, particularly if the tribe tries to kick the case under Rule 19 for sovereign immunity purposes. There's a very interesting cert petition that I think we will be talking about fairly soon. Has to do with the Klamath irrigation situation about Rule 19 and adequate representation. And if you look at the United States Department of Justice's briefing on this in the case, they're taking a very interesting position. Well, we kind of have to grudgingly admit that this other case that we don't like and we actively opposed called Dene Care, which the Navajo Nation was involved in because it had to do with our Navajo Transitional Energy Corporation and company, says that we don't adequately represent tribes under certain circumstances. We don't like the case, we're not going to defend it, but I guess it applies, so something. Well, now there's a cert petition. The United States has asked for an extension to respond. I just looked it up on the docket. And they are casting it, at least the Klamath Irrigation District, as a water rights case. That what you are saying is if we are attempting to assert our water rights vis-a-vis the United States, the tribes have the veto, and that can't possibly be. What the Solicitor General's response to the cert petition is going to be of an utmost interest, because of course, as Justice Gorsuch mentions, using the amusing metaphor of being at the DMV, we've been here before. And I think somebody, maybe it was Andrew, mentioned this position of the United States back in the 1960s in Arizona, California, that they're going to oppose the nation's intervention. They do that in 2023. Come on now. They still take that position, at least as it relates when they can outside the Ninth Circuit to a Rule 19 motion to dismiss an intervention. And of course, what you do, which is what they did in the Muskogee case in Oklahoma, is they said tribes can't even intervene at all as of right, because the Rule 19 standard, the Rule 24 standard for adequate representation is essentially the same. Oh no. And what do they say? What is the central point of their argument? We're the trustee. We are representing the tribe. We own the asset. Therefore, we're going to litigate as we see fit, and the tribe does not have a separate legal identity sufficient to overcome adequate representation. The United States Department of Justice says that today, right now. And so you look at it from that perspective, going all the way back to Arizona v. California, this is not a historical, unfortunate position. This is, and I think Andrew characterized the ongoing position of the Solicitor General. It's the same thing, which is to say that we're the trustee, we're going to litigate about your asset how we want, and if you try to interfere in a way that we don't like, we will reject and oppose your intervention. Stay tuned. They are going to have to respond to the cert petition. So from the perspective of tribes, which shouldn't be surprising, you say you own it, you say you can litigate it, we can't say anything about it. And if we try to get into the case and say something different, you will oppose and seek to destroy our ability to say anything other than what you want to say. And yet we can't enforce when we disagree with you, because now there's no enforceable trust duty. There's a general bear, and it's sort of an interesting, unironic term for tribal advocates. Oh, you have a bear trust. Oh yeah, it's a trust, but it's a bear trust. It's interesting how modifiers work in these circumstances, right? Because I think the question was, well, if they don't have to, if there's no duty, that's not exactly what the U.S. Supreme Court said. There's no enforceable duty by the courts. Now, that may be not much of a comfort for tribes, because it'll go back to, you have a bear trust. You have a trust, but you have a bear trust. There may be a duty, but it's not enforceable. So those modifiers become extremely important in terms of what they will deign to do and what they don't, and what tribes have the ability to compel them to do, because that's a bear trust. It's not enforceable. So trust us, as Justice Thomas said in his concurring opinion. If that means you trust the government, I have no problem with you trusting the government. Lots of people trust the government, et cetera, et cetera, et cetera. Thank you.
Thank you, Paul. Well put, I think.
I'll just add, I think that on the intervention point, I think that the opinion hurts the government in this realm, right? I mean, between Kavanaugh saying tribes should intervene and the force of the Gorsuch decision, I agree with you. Seeing what the government's going to do on the Klamath is going to be very interesting, and I think this case has arguably made the government's position on these issues more difficult.
Thanks, Andy. Let's move on. We got another question, and a little bit technical, but let me see if I can phrase this. So if you accept the government's assertion that the expressly accepted standard should be applied, how do you answer the response that, one, that standard was not supported by Hickory itself, since that decision reaffirmed that the court looks to common law to determine the scope of liability. Two, that it was expressly rejected by the Supreme Court in Mitchell II and White Mountain. And three, that it is potentially collaterally estopped by Navajo Tribe versus United States in the Court of Claims in 1980, which specifically relied on the holding of Mitchell II. Is there a professional responsibility on behalf of federal attorneys and their duty of candor to disclose how that how those 3 points affect their assertion of this expressly accepted standard? It's a long question.
It's a tough question. I didn't write these briefs, so I can't speak to it. I would expect that those sorts of arguments could also have been, I mean, a huge part of the briefing in the case was about Hickory and its application in this circumstance, right? So all I can say is that I don't know enough to answer your question, and but the precise contours of Hickory's application to this case, and of course the meaning of the Mitchell cases, was put before the court.
One observation, and this is the same justice who said, "What's v. Georgia? What's that?" I mean, he didn't exactly say "What's that," but he said, "Yeah, well, John Marshall was wrong. Too bad." I mean, one of the prerogatives of the Supreme Court is to reinterpret and reconstitute prior precedent and mold it to a new case and say, "Well, as we have always said, blah de blah de blah." In the Indian law context, I think the primary example that I can think of in the work that we do is Nevada v. Hicks, right? And so, Montana v. United States was clearly about non-Indian owned fee land. Then subsequent cases again, Mergen versus Hickory Apache, New Mexico versus Mescalero. Oh no, we don't have to apply Montana because that's only non-Indian fee land. Then Nevada v. Hicks comes along. When did we ever say that it was restricted to non-Indian fee land? Oh no, of course Montana applies regardless of the status of the land. Footnote, maybe not, I don't know, look over there, something. And so, I have all the sympathy in the world, and it was clearly something that came up in the briefing. If Gorsuch himself cannot convince the 5 of the usual people he runs with that Hickory did not apply in this circumstance, Kavanaugh and the rest of them are going to say what they're going to say, no matter what people say. And what it means in the future, obviously, we're not in a position to say, except to say that this is what they always do, and this is their prerogative. Whatever we may think of the restrictions of certain opinions and what they mean, they can always say it has always been our view that something, even if it was the first time you've ever heard of it. And that's the frustration, of course, as advocates, is that you think you know what the cases say until they say something else, even when you point out to them that they've said repeatedly, that's what the case says. Oh, no, in fact, the case means this. Oh, well, and on and on.
I can't really address the question specifically, but I think it falls within the general notion that I have of the court moving away from the Indianness of Indian trust cases and trying to treat at least the claims for this type of relief as if they are conventional mandamus cases against federal agencies. And certainly the application of Hickory here seems to enable it to move toward that erasure of that difference.
Great, thank you guys. So let me ask a bigger picture question. One of our attendees asks, how can Indian country weigh in effectively as the DOJ is considering cases and what policy positions it will take in a case?
I'll just say, as somebody who is recently at DOJ, there's a couple of ways to do that, right? One is to go through, I mean, DOJ is, it's ultimately, right, it makes policy for sure in some regards, but really, right, it is, when you're dealing with these issues, they're the litigators, right? They're the people who go to court on behalf of these agencies. So one place to start is with the agencies, right? And that's why, you know, elections matter so much. That's why it matters who is the Secretary of the Interior, who is the Solicitor of the Interior, who is running, who's the Assistant Secretary for Indian Affairs, because those folks can pick up the phone and they can call senior justice management and they can say, you know, we think that the department is missing something important here, or we're concerned that they're not bringing enough vigor to this dispute on our behalf, right? And that is typically the way that I think things get elevated within DOJ. I mean, I have served, I mean, I was there for a super long time. So I worked in, you know, I worked briefly in the Biden administration. I worked at 8 years in the Obama administration. I had the misfortune of working in the Trump administration. You know, depending on who's there can be a lot of access and voices can be heard. And I think the issue is to be strategic. And one way to be strategic is to identify these issues early, right? I mean, Brett can speak to the experience of working in a holding company like the Department of the Interior. There is a lot going on, and there are few people who are involved in every decision, whether that's the solicitor, the deputy secretary, the secretary, high up people who are on the, you know, anything super important they're going to be in the room on, and getting to them early and laying out a strategy, making sure that it's a, you know, it represents the consensus of as many folks as possible, and having them or White House work through DOJ, I think, is probably the most effective way. But, you know, when I was at DOJ, my view was always that I just didn't work for, you know, and one thing that's tricky, right, is in any litigation, there could be 6 federal agencies. You could have Reclamation, you could have BIA, you could have Fish and Wildlife Service, you could have Forest Service, you could have a bunch of people whose culture and mission statements puts them in tension, right? And my philosophy at DOJ was like, I work for them, but I also work for you. I work for everybody. My view is I work for everybody, right? I was a civil servant, and that to the extent that there were concerns about our views or violating a duty of candor, or you know, moving outside of the federal case law, or not living up to our commitments, there are people who are of the mindset that they need to hear from you. I know that's true for Todd Kim, who's head of ENRD, because I told him I was doing some talking to folks that I had litigated against, not this group, but a group that I spoke to earlier this week. And you know, he said, you know, if something seems odd to folks, they should pick up the phone, right? They, you know, I don't think you want to do that at every time or whatever. You want to be strategic, but I think the best people in government want to hear from you. And I would think about, once you know the people who, like, is our best lever the solicitor, is our best lever Secretary for Asia, who is the person, right? But think about pulling those levers, and also don't be afraid to pick up the call and say, hey, you know, this Deputy Assistant Attorney General is in charge of the appellate section or the Indian Resources section, and say, I want to talk to you, right? I think that's your right. And I think it's their obligation to listen. So that's Brett was the client, so I was the lawyer, so he may have some other views.
I'd like to add, I can't give an inside view. I've never worked for the federal government. However, we, you know, Brett talked about earlier the drought situation, the management of the Colorado River, and the tribes definitely are impacted by the decisions that are made. And so we have been actively involved in our effort to be heard. The tribes have banded together. We have several organizations that meet consistently and also participate in larger meetings with federal agencies. So in fact, we do have meetings from time to time, either hosted by some of the tribal organizations or BOR, and we'll have like Commissioner Tootin attend from BOR, and then also Assistant Secretary for Water and Science, Tanya Trujillo, and we are actively a part of the 10 Tribes Partnership, and we developed a relationship with the Upper Colorado River Commission, and we attend meetings with them at least once a month and attend their meetings as well. They've created a time that they meet specifically with the tribes to talk about, all of these issues, these management issues, the guidelines, the SEIS that came out, and we try to team up with with our allies in order to have the tribal perspective and how the tribes will be impacted included in these decision-making processes. So I just wanted to add that.
One other observation on this, it's more of a rhetorical question because we don't know the answer to this, but I appreciate the description of how tribes can advocate. This case has been going on for 20 years. It was filed in 2003. It went through a number of presidential administrations, but the decision to file cert by the Solicitor General on this case, it didn't have to do that. It didn't have to take this up all the way to the Supreme Court. There could have been a way of dealing with this at the Ninth Circuit level before the en banc, before affirmatively filing. Once you affirmatively file a cert petition, you are taking a very public, specific position, the name of the individuals who are named on the caption of the case. And given the people who are named on the caption of the case, my rhetorical question is, how did this happen? And that's it. That's all I have to say about that.
I might add that, so I had some frustration during my time at Interior with what I thought of as the deeply ingrained small c conservatism of the Justice Department, whose interest, it seems, and I mean, I think it's consistent with some of what Andy said earlier, seems to be to maintain maximum executive discretion where possible, and to maintain the sovereign prerogatives of the United States as sort of paramount interests in the way that it sees the world. And of course, that is often, those ideas are often in some tension with the kinds of requests or claims that were being made in this case about what the government ought to be doing. It helps certainly to have the Secretary of the Interior and the Solicitor of the Interior and other agency heads advocating within Interior for a certain position. But the small c conservatism of the Justice Department is there. It's a fact of life. And in some sense, maybe the Justice Department has is kind of has a stronger voice within many administrations than perhaps the Secretary of the Interior. And so as an advocacy perspective, I think this suggests why it's so important to have an office within the White House that is focused on, in this case, Indian affairs or Indian issues, and to cultivate that kind of understanding and relationship within the White House itself, because the White House ultimately will resolve any differences of opinion on legal issues or other issues between the Justice Department and the Interior Department or any other agency. So I think it's really important to continue to push for that type of office and for access to that type of office within the executive office of the president, who is the executive and has to resolve these kinds of policy disputes.
Thank you, guys. Time maybe for one or two more questions here. So another attendee asks, does the Thomas concurrence provide some foreshadowing of a possible position, I guess, of the United States in the case that you were referring, Paul? I am assuming the attendee means the Klamath case that you referenced. So does the Thomas concurrence provide some foreshadowing of the United States' possible position in that case?
Oh man, I sure hope not. I can't imagine even this particular Solicitor General's office taking a position that the trust responsibility is made up and doesn't really exist. And why do people keep talking about it? And the canons of construction are made up. Why is that a thing? See Amy Coney Barrett's law review article. Apparently, Thomas believes that even she wouldn't sign on to something that cites her own law review article for this alleged proposition, at least from what I recall. Thomas, in a broader sense, in Indian law is an outlier, right? We know his sort of, shall we say, eccentric views on certain things. I think he repeated it in Brackeen. But I will say, reading it sort of objectively and extracting certain things out, there are some, I think, valid points that he said, not just in this case, but throughout other ones, which is, how could this be? How could it be that tribes are sovereign, but the United States can destroy their sovereignty completely, allegedly under plenary power? How could it be that the United States is the trustee, but then can tell tribes absolutely what to do, and the tribes have no agency whatsoever? None of that makes sense. I don't disagree with that. One of the interesting things in Brackeen, one of the sort of threads going on in this discussion, Gorsuch picks up on something I think Professor Blavsky's amicus brief talks about, that plenary doesn't mean absolute, and that it is limited to managing the relations between tribal nations and non-Indians, but it is not the power of Congress to destroy tribal sovereignty. That the sort of Kagama, and I hope Indian law advocates dispense with citing Kagama ever again for this proposition, because this is what he's talking about. And I agree with him on this. And internally between us, there's been a lot of discussions among various people as to whether you should cite Kagama and why. The once powerful race now weak and defenseless, and therefore the United States has to have this authority. And where does plenary power see Kagama, right, as sort of a knee-jerk way of justifying congressional power. But so some of what he's talking about isn't completely, to use the technical term, bonkers, but this idea that the trust relationship doesn't exist, even US DOJ, even the Solicitor General, I don't see any possibility that they would, with a straight face, particularly with Gorsuch glaring down at them from 5 feet away, given how close the advocates are, would purport to say, oh, Thomas is right, it's all made up. What is this thing? It doesn't exist. But maybe I'm a little optimistic as to the limits even US DOJ would place on itself to make what, again, from a technical sense, is a bonkers assertion.
Thanks, Paul. Any other, Andy, Brett, any other thoughts on that?
You never want to say never, but I do think Thomas's views here are somewhat idiosyncratic, I guess more than somewhat. And I agree with Paul on his observation about the kernels, but I don't think that I'm not overly concerned about Thomas's idiosyncratic views being adopted in the in the mainstream. And I feel like that's another win here, right? We just had Thomas reasserting his he's got a macro on these things. It showed up in Brackeen, it showed up here, but it doesn't persuade anyone else. And I think the person I guess we worry, I think was probably people on this call know better than I think was in the Isleta case, the advocate for the SG's office was asked about the canons of construction, I think maybe by Alito. So, he's somebody that worries me, but the two of them in this area, I don't see that their views getting moving into the mainstream.
Citing Professor Barrett's law review article was not enough to get Justice Barrett to join the dissent.
Great. So I think we have time for one more quick question here. And I think it's one that is people ask sometimes if they know a little bit of the history, not just of this case, but the law of the river, the Colorado River. So why is it, and could there a case be made that the government ignored its own advice? As you recall, the history, the law of the river involves this assessments of how much water was in the river, and widely accepted, known now that the basis of those quantifications were off, massively off. So is there something to be said, or a case to be made that the government has ignored science, in this case, its own science? And is that something that, the tribe should press forward with?
Well, if we're talking about the compact and the understanding based on an unusual high flow decade in the early 20th century of how much water there was in the river that led to the Colorado River Compact, yes. I mean, to some extent, the government is ignoring new science, which shows that understanding to be completely wrong, even wrong at the time, as a prediction of how much water there is in the river. Unfortunately, compact law under the Constitution doesn't just allow the government to say, oh, we were wrong, and that compact and those compacts then are just going to have to be reworked. And I'm not sure that anyone, well, I'd be interested to hear whether there are any tribes that think so, but I'm not sure that there are any states who would prefer renegotiating from the start the interstate or other allocations to building on the very complicated and nuanced and layered law of the river through these sorts of side agreements and individual settlements that have been going on. Now, of course, the tribes here, having for decades fought to have its water rights recognized and identified specifically. So perhaps they have some different notion. I'm not sure renegotiating the compact based on a proper scientific understanding is necessarily going to lead to a better situation for the tribes or other users on the river.
Any thoughts from the nation?
I know this will be one that Paul would kick to me. This is a water question. It's interesting, and it's interesting with what Brett just said about renegotiating the compact. One thing that we always tribes complain about is that we weren't part of that decision making. And so that's definitely something to think about, what kind of impact it could have. So I guess that's the only answer that I have, thinking about it, because, we do, like I said before, we want to be heard in any kind of decision making, over the management of the river, because we see that that's our water too. And, being left out of decision making has not helped anyone, not just the tribes. Everyone is still impacted, by all of by all of this, including, who was left out of the discussions and decision making even back in 1922.
The great point that what if in 1922 the folks thinking about this issue had considered traditional ecological knowledge, had given the nation a seat at the table, would better decisions have been made? I think the question goes, I mean, John Fleck, New Mexico water expert and journalist, has written a book about this failure in 22 for the government to listen to its own USGS expert on what the true state of the river and the basin was. It's an interesting case study, because just one of the things Justice Gorsuch does not believe in is deference to the agency, presumably even with regard to scientific expertise. And it doesn't take anyone particularly long to find issues where the government has failed to listen to its own expert or gotten things wrong, and that feeds a narrative about sort of is government capable of getting these things right.
And you also have to remember the other pressures out there, and I think about corporate, and even after everyone talks about winters and how important it is, and it is. However, the 22 compacts happened after winters, and it's about the wants and needs of other parties, and not really about just about access to water or human rights. So even if we were involved, who knows where it would go. So, because that's a whole nother group of interests that are out there.
Great, thank you. I think our clock is running out. So any last comments anybody wants to make before we close out?
Well, thank you. Thank you to our panelists for taking the time out of your Friday to talk about this case and reminding everyone of its importance. Thank you to all of our attendees and to John for ably moderating. And we hope to see many of the attendees back in September for our next webinar.